CPC, place of suing. Suits may be of different types. They may relate to movable properties or immovable properties. They may be based on contracts or torts. They may be matrimonial proceedings, suits for accounts, and so on. Jurisdiction of a court to entertain, deal with, and decide a suit may be restricted by a variety of circumstances. And the first thing which is to be determined is the place of suing. Sections 15 to 20 of the Code of Civil Procedure regulate the forum for the institution of suits. Section 15 requires the plaintiff to file a suit in the court of lowest grade competent to try it. Section 16 to 18 deal with suits relating to immovable property. Section 19 applies to suits for compensation. For wrong to a person or to a movable property. Section 20 is a residuary section and covers all cases not dealt with by Section 15 to 19. Section 21 recognizes the well-established principle that the defect as to territorial or pecuniary jurisdiction can be waived. It forbids appellate or revisional court to allow objection as to the place of suing or pecuniary limits. Section 21A bars a substantive suit for setting aside a decree passed by a court on the ground of want of territorial jurisdiction, pecuniary jurisdiction. General rule. Every suit shall be instituted in the court of the lowest grade competent to try it. Nature and scope. Section 15 of the Code refers to the pecuniary jurisdiction of the court. It states that every suit should be instituted in a court of the lowest grade competent to try it. The rule laid down in the section is a rule of procedure and does not affect the jurisdiction of the court. Hence, a decree passed by a court of a higher grade cannot be said to be without jurisdiction. It is merely an irregularity covered by Section 99 of the Code, and the decree passed by the court is not a nullity. Object. The object underlying this provision is twofold: to see that the courts of higher grade are not overburdened with suits, and to afford the convenience to the parties and witnesses who may be examined in such suits. Thus, Bombay, Calcutta, Madras High Courts are having original jurisdiction like city civil courts and small causes court. The pecuniary jurisdiction of a small causes court, say, is up to 50,000 rupees. Therefore, a suit to recover 5,000 rupees as damages for breach of contract can be tried by any of the courts, but according to Section 15 of the Code, a suit must be filed in the lowest court, that is the small causes court. But if the suit is filed in a city civil court and the decree is passed by that court, it is not a nullity. Mode of valuation. Prima facie, it is the plaintiff's valuation in the plaint that determines the jurisdiction of the court and not amount for which ultimately the decree may be passed by the court. Thus, if a pecuniary jurisdiction of the court of the lowest grade is say 10,000, and the plaintiff files a suit for accounts and finally court finds on taking account that it is 15,000 that are due, the court is not deprived of its jurisdiction to pass a decree for that amount. In case of Kiran Singh versus Chaman Paswan, a suit was valued at 2950 and was filed in the court of subordinate judge Mongir. The suit was dismissed and the plaintiff filed an appeal in the district court. That appeal was also dismissed by the district court and the second appeal was filed in the High Court of Patna. The High Court held that the correct valuation was 9,880 and directed the appellant to pay the deficit court fee. On the realized valuation, the suit would be within the competence of the subordinate judge where it was filed, but an appeal against the decree would lie directly to the High Court and not to the district court. The appellant in these circumstances contended before the High Court that the appeal to the district court was incompetent and the decree passed by the district court was a nullity, and that the second appeal should be treated and heard as a first appeal. The High Court negatived the contention and dismissed the appeal as no prejudice was shown. The matter was taken to Supreme Court. While affirming the decision of the High Court, the Supreme Court held that the decree passed by a district court was not a nullity and that a mere change of forum could not be said to have caused any prejudice to the appellant. The decree passed by the district court was therefore upheld. Power and duty of the court. Usually, court will accept a valuation of the plaintiff in the plaint and proceed to decide the suit on merits of justice. That does not, however, mean that the plaintiff in all cases is at liberty to assign any value to the suit and to choose the court in which he wants to file a suit. If the plaintiff deliberately undervalues or overvalues the claim for the purpose of choosing the forum, the plaint cannot be said to be correctly valued, and it is the duty of the court to return it to be filed in a proper court. If it appears to the court that the valuation is falsely made in the plaint, For the purpose of avoiding the jurisdiction of the proper court, the court may require the plaintiff to prove that the valuation is proper. When there is objective standard of valuation, to put a valuation on the relief ignoring such objective standard might be a demonstratively arbitrary and unreasonable valuation, and the court would be entitled to interfere in the matter. But if the court is unable to come to a finding regarding the correct valuation of the relief, the court has to accept the valuation of the plaintiff. Objection as to jurisdiction, territorial jurisdiction. Next time. Types of suits. For the purpose of territorial jurisdiction of a court, suits may be divided into 4 classes. Suits in respect of immovable property, suits for movable property, suits for compensation for a wrong or a tort, and other suits. Immovable property, section 16 to 18. Section 16 to 18 deal with the suits relating to immovable property. Clauses A to E of section 16 deal with the following 5 kinds of suits. Suits for recovery of immovable property, suits for partition of immovable property, suits for foreclosure, sale or redemption in case of mortgage of or a charge upon immovable property, suits for determination of any other right to or interest in immovable property, and suits for torts to immovable property. These suits must be filed in the court within the local limits of whose jurisdiction the property is situated. This is very clear and simple and does not create any difficulty, but that will happen if the property is situated within the jurisdiction of more than one court. Section 17 of the code provides for this contingency. It says that where a suit is to obtain a relief respecting or a damage of tort to the immovable property situated within the jurisdiction of different courts, the suit can be filed in the court within the local limits of whose jurisdiction any portion of the property is situated, provided that the suit is within the pecuniary jurisdiction of such court. This provision is intended for the benefit of suitors and to prevent multiplicity of suit. A case may, however, arise where it is not possible to say with certainty that the property is situated within the jurisdiction of one or the other of the several courts. In such a case, one of these courts, if it is satisfied that there is such uncertainty, may, after recording a statement to that effect, proceed to entertain and dispose of the suit. Movable property, section 19. It has been said movables to follow the person, mobilia sequenter personam. A suit for the wrong to a movable property may be brought at the option of the plaintiff either at the place where the wrong is committed or where the defendant resides, carries on business, or personally works for gain. Where such wrong consists of a series of acts, a suit can be filed at any place where any of these acts have been committed. Similarly, where a wrongful act is committed at one place and the consequence ensues at another place, a suit can be instituted at the option of the plaintiff where the action took place or the cases ensued. Illustrations. A residing in Delhi beats B in Calcutta. B may sue A either in Calcutta or Delhi. A residing in Delhi publishes in Calcutta statements defamatory to B. B may sue A either in Calcutta or in Delhi. A residing in Delhi publishes in Calcutta statements defamatory to B. The newspaper is circulated in Bombay, Madras, and Raipur. B sues A either in Calcutta or Delhi or Bombay or in Madras or in Raipur. Compensating for the wrong, section 19. A suit for compensation for the wrong to a person may be instituted at the option of the plaintiff either where such wrong is committed or where the defendant resides and carries on business or personally works for gain. Other suits, section 20, provides for all other cases not covered by any of the foregoing rules. All such suits may be filed at the plaintiff's option in any of the following courts, namely, where the cause of action wholly or partly arises or one where the defendant resides or carries on business or personally works for gain, or 3, where there are 2 or more defendants, any one of them resides or carries on business or personally works for gain, provided that such case A, either leave of the court is obtained or the defendants who do not reside or carry on business or personally work for gain at that place acquiesced to in such institution. Illustrations. A is a tradesman in Calcutta. B carries on business in Delhi. By his agent in Calcutta buys goods of A and requests A to deliver them to the East India Railway Company. A delivers the goods accordingly in Calcutta. A may sue B for the price of goods either in Calcutta where the cause of action has arisen or in Delhi where B carries on business. A resides at Simla, B at Calcutta and C at Delhi, A, B and C being together at Banaras. B and C make a joint promissory note payable and demand and deliver it to A. A may sue B and C at Banaras where the cause of action arose. He may also sue them at Calcutta where B resides or at Delhi where C resides. But in each of these cases, if the non-resident defendant objects, The suit cannot proceed without the leave of the court. Section 20 of the code has been designed to secure that justice might be brought as near as possible to every man's hearthstone, and that the defendant should not be put to trouble and expense of travelling long distances in order to defend himself in cases where he may be involved. Section of the forum. It is a well-settled principle of law that the consent can neither confer nor take away any jurisdiction of a competent court. The same principle applies to ouster of jurisdiction of a court. Where the court has jurisdiction, neither consent nor waiver nor estoppel nor acquiescence can oust it. An agreement to oust absolutely the jurisdiction of a competent court is void, being against public policy, ex dolo molo, non oritur actio. But when two or more courts have jurisdiction to entertain a suit, an agreement by the parties to submit to the jurisdiction of one of the such courts to the exclusion of the rest is valid, binding and enforceable. Jurisdiction as to subject matter. Different courts have been empowered to decide different types of suits. Certain courts have no jurisdiction to entertain certain suits. For instance, presently small courts have no jurisdiction to try a suit for specific performance of a contract. Likewise, suit for testamentary success, succession, divorce case, probate proceedings, insolvency matters cannot be entertained by a court of civil judge junior division. This is called jurisdiction as to the subject matter of the suit. Where a court has no jurisdiction over the subject matter of a suit, there is an inherent lack of jurisdiction, and a decree passed, judgment rendered, or order made is a nullity on the face of it. Place of suing general principles. The provision of Code of CPC relating to the place of suing may be explained by the following chart. Nature of a suit or place of suing. 1. Every suit, court of lowest grade competent to try it, section 15. Suits for recovery, court within whose jurisdiction the immovable property is situate. 16. Section 16A to E. Partition of, foreclosure, sale, redemption of mortgage or charge upon, determination of any other right or interest in and compensation for wrong to the immovable property. Next, 3. Recovery of movable property under actual distrite or attachment, court within whose jurisdiction the immovable property is situate. This provision is based on the well-known maxim, equity acts in personam. See observations of Lord Selberg in Ewing versus Ewing. Nature of suit or place of suing. Relief respecting or court within whose jurisdiction. Compensation for wrong to immovable property held by or on behalf of the defendants, where the relief sought can be entirely obtained through his personal obedience. The property is situated, or the defendant resides or carries on business or personally works for gain. Proviso to section 1619A. Relief respecting or the court within whose jurisdiction any portion of the property is situate. Provided that the entire claim is within the pecuniary jurisdiction of such court. Compensation for wrong to immovable property situate within the jurisdiction of different courts. Where it is uncertain within the jurisdiction of which of the two or more courts any immovable property is situate, any of those two courts, provided that the court has pecuniary jurisdiction and jurisdiction as regards the subject matter of the suit. Section 18. Compensation for wrong to in either of the courts at the option of the plaintiff. In 1. A person or movable property. If the wrong is so done within the jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the jurisdiction of another court. Any other suit where the cause of action wholly or partly arises, or where the defendant resides, carries on business or personally works for gain, or where there are two or more defendants where any of them resides, carries on business or personally works for gain, provided that forum shopping. Forum shopping. The Supreme Court has not only disapproved but strongly deprecated the practice and increasing tendency on the part of litigants of crossing a forum which may oblige them by entertaining suits or petitions, though they have no jurisdiction in the matter. In Union of India versus Oswald Woolen Mills Limited, though the registered office of the company was at Ludhiana, Punjab, a petition was filed against it in High Court of Calcutta, and ex parte ad interim relief was obtained by the petitioner. Supreme Court set aside the order and observed the action was taken as a part of the maneuvering legal battle. In Morgan Stanley Mutual Fund versus Karthik Das, Supreme Court stated there is an increasing tendency on the part of litigants to indulge in speculative and vexatious litigation, and adventurism which the fora seem readily to oblige. We think that such a tendency should be curbed. In ONGC versus Utpal Kumar Basu, though no cause of action arose in Calcutta, High Court entertained the writ petition and granted interim relief to the petitioner, observing that it was a great pity and one of the premier high courts had developed a tendency to assume jurisdiction on unsustainable grounds. The Supreme Court said, "We are greatly pained to say so, but if we do not strongly deprecate the growing tendency, we are afraid, be failing in our duty to the institution and the system of administration of justice. We do hope that we will not have another occasion to deal with such a situation." Nature of suit, a place of suing. Either the leave of the court is obtained, or defendant who do not reside carry on business or personally work for gain, acquiesce. Next, objection as to jurisdiction, section 21. As stated above 24, it is a fundamental rule that a decree of a court without jurisdiction is a nullity. Asbury rightly states that where, by reason of any limitation imposed by statute, charter or commission, a court is without jurisdiction to entertain any particular action or matter, neither the acquiescence nor the express consent of the parties can confer jurisdiction upon the court, nor can consent give a court jurisdiction if a condition which goes to the root of the jurisdiction has not been performed or fulfilled. Where a court takes upon itself to exercise the jurisdiction it does not possess, its decision amounts to nothing, nullity. This does not, however, apply to territorial or pecuniary jurisdiction, inasmuch as the objections to such jurisdictions are regarded by the court as merely technical, and unless raised at the earliest possible opportunity, they will not be entertained in appeal or revision for the first time. Object underlying section 21 is to protect the honest litigants and to avoid harassment to plaintiffs who have bona fide and in good faith initiated proceedings in a court which is later on found to be wanting in jurisdiction. Dishonest litigants cannot take advantage of this provision. Objection as to territorial jurisdiction. It is well settled that the objection as to the local or territorial jurisdiction of a court, place of suing, does not stand on the same footing of a court to try the case. Competence of a court to try a case goes to the very root of jurisdiction, or where it is lacking, it is a case of inherent lack of jurisdiction. On the other hand, an objection as to the local jurisdiction of a court can be waived, and this principle has been recognized by section 21 of the code. Thus, in Hiralal versus Kalinath, where the suit which ought to have been filed in an Agra court was filed in the Bombay High Court with the leave of the court, it was held that the objection to such jurisdiction falls within the section 21. Under section 21(1), no objection as to the place of suing will be allowed by an appellate or a revisional court unless the following three conditions are satisfied. Objection was taken in the court of the first instance, it was taken at the earliest possible opportunity, and in cases where the issues are settled at or before settlement of issues, there has been a consequent failure of justice. All three conditions must coexist. The reason is obvious. The reason is obvious. It is well settled that neither consent nor waiver nor acquiescence can confer jurisdiction upon a court, otherwise incompetent to try a suit. However, it is equally well settled that the objection as to the local jurisdiction of a court does not stand on the same footing as the objection as to the competence of a court to try a case. Competence of a court to try a case goes to the very root of jurisdiction, and where it is lacking, it is a case of inherent lack of jurisdiction. On the other hand, an objection to the local jurisdiction of a court can be waived. Section 21 is a statutory recognition of the said principles and provides that the defect as to the place of suing under section 15 to 20 may be waived if the defendant allows the trial court to proceed to decide the matter without raising an objection as to the place of suing and takes the chance of a verdict in his favor. He clearly waives the objection and will not be subsequently permitted to raise it. It is even possible to say that the long and continued participation by the defendant in the proceedings without any protest may in appropriate cases amount to a waiver of an objection. The policy underlying section 21 has been succinctly explained in Supreme Court in Kiran Singh versus Chaman Paswan, wherein their lordships observed Where a case has been tried by a court on merits and judgment rendered, it should not be liable to be reversed purely on technical grounds, unless it has resulted in failure of justice, and the policy of legislature has been to treat objections to both territorial or pecuniary jurisdiction as technical and not open to consideration by the appellate court unless there has been a prejudice on merits. But the section does not preclude objections as to the place of suing being taken in the appellate or a revisional court if the trial court has not decided the suit on merits. Objection as to pecuniary jurisdiction. As discussed above, as a general rule, it is the plaintiff's valuation and the plaintiff that determines the jurisdiction of the court and not the amount for which ultimately the decree may be passed by the court. But if the defendant disputes the valuation put by the plaintiff, it is the duty of the trial court to inquire into it and pass an appropriate order. But no objection as to the overvaluation or undervaluation will be allowed by any appellate or revisional court unless the following three conditions exist. The objection was taken in a court of the first instance. 2. It was taken at the earliest possible opportunity and in cases where issues are settled at or before settlement of issues and there has been a consequent failure of justice. All these three conditions must coexist at the same time in the same case. A files a suit. Illustration. A files a suit against B to recover possession of a house. He values his claim in the plaintiff at ₹8,000. The suit is filed in court C, which has jurisdiction to try suits of a value up to $10,000. The market value of the house is ₹12,000. But B does not object to the jurisdiction of the court. The decree is passed in favor of A. In appellate court, B cannot take the objection about the pecuniary jurisdiction of the court C. Thus, in Kiran Singh versus Chaman Paswan, negativing the contention of the appellant that a mere change of forum can be said to have caused prejudice to him, the Supreme Court rightly observed, if the fact of an appeal being heard by a subordinate court or a district court, where the appeal would have laid to the High Court if the correct valuation has been given, is itself a matter of prejudice, then the decree passed by the subordinate court must, without more, be liable to be set aside. And the words unless overvaluation or undervaluation thereof has prejudicially affected the disposal of the suit or appeal on its merits would become wholly useless. These words clearly show that the decrees passed in such cases are liable to be interfered with in the appellate courts, not in all cases, not as a matter of course, but only if the prejudice such as is mentioned in the section results, and the prejudice envisaged by the section therefore must be something other than the appeal being heard in a different forum. Wherever there has been a prejudice or not is a matter to be determined in the facts of each case. Objection as to subject matter of jurisdiction. A court cannot adjudicate upon a subject matter which does not fall within its province, as limited or defined by law. A jurisdiction as to the subject matter of a suit is regarded as essential for jurisdiction over the subject matter, is a condition precedent or sine qua non to the acquisition of authority over the parties and the matter. And if the court does not possess that jurisdiction, a judgment given, order made or decree passed is absolutely null and void, which may be set aside in appeal or review or revision. Its validity can be challenged even in collateral proceedings. Objection as to the subject matter of jurisdiction. A court cannot adjudicate upon a subject matter which does not fall within its province as limited or defined by law. Okay. Objection in execution proceedings. Subsection 3 of the section 26 makes it clear that the principles of this section apply to execution proceedings also. The question of objection as to jurisdiction of the court in EP can be discussed under two heads: position prior to Amendment 76, position after Amendment 76. Position prior to Amendment 76. 21 of the Code as originally enacted did not in terms apply to execution proceedings. There was therefore a difference of opinion whether the principle of Section 21 would govern execution proceedings. Also, no doubt in Hiralal versus Kalinath, Supreme Court applied the principle of Section 21 to execution proceedings also. Now, position after Amendment of 76. With a view to avoiding delay in execution proceedings, an express provision has been made in the Code in 76, which specifically provides that an objection as to territorial jurisdiction of the court executing the decree should not be allowed unless the condition laid down therein are fulfilled. 3 conditions. Bar of suit, section 21A. It is clear from the above discussion that as per section 21, no objection to the place of suing can be taken at appellate or revisional stage of the proceedings. But can that decision be challenged by filing a new suit? There will be conflicting decisions on that point. Section 21A, as instructed in 76, now specifically provides that no substantive suit can be filed to set aside a decree passed by a court on an objection as to the place of suing. The provision, however, is ambiguous and defective and incomplete. It speaks of place of suing, territorial limits only, and does not deal with pecuniary limits or defects. It is, however, admitted that the principle applicable to territorial defects will pro tanto apply to pecuniary defects as well.